Friends, good late morning slash early afternoon, or at least that's what time it is here in Los Angeles. Welcome to another edition of SPTV News Live. Now, today's shenanigans, let's call this shenanigans number 3 in this case that we're going to be talking about in this latest update. What we're discussing is the civil trial of Danny Masterson that the Jane Does who were in the original criminal trial of Masterson are now moving over to civil case mode, and they're suing Danny Masterson, the elf David Miscavige, and the cult of Scientology, alleging that they've been stalked and harassed, i.e., fair gamed in Scientology nomenclature since around 2017, when the LAPD began seriously looking into these allegations, all the way up to present time. Now, last week, since the criminal trial officially finished on September 7th, 2023, and Danny Masterson got a life sentence, they had a hearing last week to see if they could remove the stay and proceed forward with the case, which did in fact happen. So this just happened last week where they got a trial date set in August of 2025 for this civil case. And already there's been 3 incidences, and there'll be many more as predicted in the last video appertaining to this, of Scientology doing everything that they can to sling mud into this to create as much irritation and gaslighting techniques because they have to follow Hubbardиan policy. It's literally written as to how to handle the law. So there's already been 3 shenanigans in this trial just in the last week. The first one being they tried quite hard to keep the case on stay so it wouldn't go forward. The judge turned that down. In the last video that we did, this had to do with shenanigans number 2, called Scientology's desperate attempt to silence Jane Doe's and Danny Masterson's civil lawsuit. And that had to do, without getting too complex, please check that out to follow that. But to keep it brief, they accused the judge basically, not even basically, they accused the judge of lying on a ruling that's already been set, where the previous lawyers for Danny in the criminal case, that would be Applebaum and Mesereau, were fined $900 for leaking information to the cult of Scientology, which is illegal. And since the Jane Does brought that up recently as something to pay attention to in this upcoming civil trial, Scientology then got in there and said, here's why the ruling was wrong, Judge, and why we didn't do anything wrong. Again, if you want to see the details of that, please check out that video. And the third shenanigans just in has to do with the following. So let us get into this, and I'll throw you guys in the chat so you should be able to read that. This won't be too long of a video, but it gives us some real interesting insight on this judge. If this is anything to go by, they're going to have a hard time, Scientology, pulling fast ones, trying to delay, and the tactics that they're used to doing, because you're going to see just how the judge handled Scientology's objections and how quickly he kind of whipped through things, their stalling tactics. So last week, let me pull the chat over here, guys. Good morning, by the way. It's good to see you guys. So last week, Judge Upinder Kalra, I'm probably not pronouncing that right. Apologies. Let's go with Kalra. So Upinder Kalra lifted the stay on the Bixler versus Scientology lawsuit. Again, those are the Jane Does versus Danny Masterson, cult leader Miscavige, and Scientology for alleged harassment and stalking. And it's a civil lawsuit, which has been on hold while Danny Masterson's criminal trials were going on. That's the lawsuit that was filed in 2019 by Masterson's victims against Danny and the cult, accusing them of a campaign of harassment. So now that Masterson's been sentenced, Judge Kalra lifted the stay on the lawsuit over the strong objection of Scientology's lawyers. Scientology's attorneys, that would be William Forman of the cult, Robert Mangels of RTC, or Religious Technology Center, as well as Andrew Brettler for serial rapist Masterson, argued that the lawsuit should stay on ice for now, but Judge Kalra disagreed, and you're going to see more into that. And by the way, here's a quick picture to give you the mass, as they say in Scientology, of what a couple of these judges look like that are, or not judges, the lawyers for Scientology. So on the left here, we have Scientology attorney Forman and the aforementioned Mangels on the right, and they're not happy with the judge. Okay, now they have filed a motion carping that the good judge, in his minute order, that's kind of like a log, made it sound like all sides agreed to lift the stay, and they want him to correct the record. Quote, the defendants respectfully request that this objection be sustained and the court correct the minute order to reflect that the lifting of the stay was over the objections of the defendants. And by the way, just to clear some nomenclature, we do a lot of word clearing in the cult, so why not apply it here? Just so we don't get lost in the legalese gobbledygook, because there's quite a bit coming up. A minute order is a legal document. It's a court's answer to a party's request. In legal terms, this request is called a motion. A minute order is basically a court's answer to or ruling on a particular motion. So the reason that we're bringing this up is not kind of what we just covered so much. It's Scientology's attorney. It's not what they're just complaining about, because it's basically irrelevant what I just read you. And like I said, it's all part of their stalling tactics and getting under the skin of people and basically trying to do anything they can. And they'll do much more before that August 2025 date comes about. They're going to try to make that as hard and as long and stalled out as possible. But Scientology, in ever foot bullet fashion, because they added to this the actual word for word dialogue of what went down in the courtroom when they objected to the stay. And last week it was covered by people's notes that were in the courtroom, but we actually get to hear the word for word what went down. And like I said, it's telling of the judge that we're dealing with and Scientology's tactics. So they actually attached a transcript of last week's hearing, and that's what I want to read from the beginning. It's not too long. There is some legalese gobbledygook. I'm not a frickin' lawyer, but I do understand basically what this is about, and I'll translate it at the end. But get a load of this. So Judge Upinder Kalra. So this is, again, the Chrissy Bixler et al. Versus the cult of Scientology. So we have counsel in the court. We have lots of counsel on Court Connect. We have a court reporter on Court Connect. Please speak clearly, slowly, and loudly. And please identify yourself when speaking. We're going to start with counsel in court. Counsel, appearance. Stand by for a drink of water. This is one of Scientology's attorneys. Andrew Brettler. Good morning, Your Honor. Andrew Brettler for defendant and serial rapist, Danny Masterson. Judge. Okay. And who do we have for the plaintiff, Jane Doe? Brad Edward responds. Brad Edwards for Jane Doe, number one. Judge. That's one plaintiff. And plaintiff Bixler, that's in reference to Chrissy Carnell Bixler, one of the plaintiffs. Allison Anderson says, we represent the remaining plaintiffs, Allison Anderson and John Casera on the line. Judge, okay. And is there a Simon Lean? Anderson, he's not here today. Thank you. Judge, okay. And now the defendant, cult of Scientology. Do we have counsel on Court Connect? William Forman, yes. William Forman and Margaret Dayton for defendant, cult of Scientology International and cult of Scientology Celebrity Center International. Judge, okay, all right. Robert Mangels, yes, Your Honor. Robert Mangels and Matthew Hinks, again, lawyers for the cult of Scientology. Judge Kalra, okay, I hope I got everyone. I know there's some observers as well. Did I get the appearances of counsel? Today's the date. We put this over whether or not to lift the stay. Again, if you're just joining us, we're dealing with the word for word translation of what actually went down during this objection by Scientology to not lift the stay. I did read the joint status conference filed on September 25th. There was an objection to take judicial notice. This is just a status conference. I'm not taking judicial notice or not judicial notice of anything at this point. This is just to get the respective positions on whether or not the court should lift the stay. Easy enough, right? But nothing's quite easy with Scientology in the picture. I understand that serial rapist Masterson has been sentenced. I'm also understanding that he still enjoys the Fifth Amendment privilege against self-incrimination because there's an appellate process. That means an appeal process. But while that Fifth Amendment is not waived, this case has been on abeyance for a significant period of time. It was filed on August 22nd, 2019. I know the court, and including prior bench officials, stayed the action to allow the criminal proceedings to proceed. There was a first trial, it was a mistrial, there was a second trial and a conviction. And although defendant Masterson still enjoys the Fifth Amendment privilege, it seems to me on balance at this point we can proceed. And whether Masterson invokes the Fifth in regards to any discovery request, we take that up individually. Those are challenges plaintiffs will face. And just to show you what that actually means here real quick, what discovery is. If a lawsuit gets past its initial stages, the plaintiff and the defendant will go through a period of discovery. This involves asking the opposing party or other people to provide information that would not be publicly known or readily available to the party seeking it. Carrying on. And plaintiff is asking that we proceed. Now, be careful what you wish for, plaintiff. This is in reference to the Jane Does that want to go forward with this. If I lift the stay, that 5-year clock will start again. And if you're being challenged in getting discovery, because defendant Masterson will continue to enjoy the Fifth Amendment privilege until the appellate process works its way out, and I would venture to guess 60 days to file a notice of appeal. It will take a significant period of time for the record on appeal to be prepared. And notice the judge's warning and asking the Jane Does, are you sure you want to actually start the clock here? And therefore, after the record is prepared, the appellate court, depending on the division, they each have different paces. But I'm being ambitious. 2.5 to 3 years before an appellate opinion issues. I don't know what appellate issues are going to be raised. I'm not going to comment on that. But after an appellate opinion is issued, there would be a petition for a rehearing. Following a petition for rehearing, there's going to be a petition for review. So 3 years, easy. And if you want me to lift the stay and you come back later and say additional time should be told because we couldn't get discovery, please know basically that you're making this request with your eyes wide open. So you'd be hard pressed to make that argument with this knowledge. Again, the judge is just making sure that Jane Does know what they're doing by lifting the stay. Plaintiff, are you sure you want me to lift the stay? Who would like to be heard? Edwards, on behalf of Jane Doe number 1, yes, we'd like to stay lifted. Sounds like these guys are ready to go and they've already thought this out. Judge, okay, remaining plaintiffs, Anderson, we agree as well, Your Honor. Judge, you're doing it with eyes wide open, Counsel Edwards? Edwards, yes, Your Honor, we understand that's the risk and the problems going forward. Let's get it on. I added that last part, obviously. Judge, Counsel Anderson, same, yes, we understand. So the judge says, so defense, I understand you might, defense, who would like to be heard for Sierra rapist Masterson? Brettler speaks up, Your Honor, for Masterson, I set forth our position in the status conference report. As the court recognizes, Mr. Masterson still is entitled to the Fifth Amendment protection, not only because of the appeal, but the third mistried count is still viable and can be retried. This is Chrissy Carnell Bixler, which was the one that still has a chance to be retried. So the stay should remain in place with respect to Mr. Masterson through the time the appeal is fully resolved and the government decides to dismiss that third count with prejudice. Judge says, and for the cult of Scientology, who would like to be heard? Forman, Your Honor, this is Bill Forman for the cult of Scientology International. I think the most important factor that needs to be addressed here is we were just informed yesterday by the plaintiff's counsel that they intend to file an amended complaint in this matter. Again, this appertains to the other video that I just showed you to know more about this. We had asked them at the meet and confer last week what their intentions were with that, and they said, we'll get back to you. They told us yesterday at 4:30. I responded immediately. What are the grounds for the amendment, the new allegations? What are the new causes of action? I did not even receive an acknowledgement of my email. We cannot be put in a position of propounding and responding to discovery if there's going to be an amendment. So I would suggest, Your Honor, the stay continue while they get us their proposed amendment. We see if we stipulate to the filing of it or whether they need to file a motion for leave to file the amendment because we have no idea what we're facing now. We don't understand why they hid them for so long and cannot even tell us what the grounds for amendment are. Judge, the only thing before me is the current pleadings. Whether or not they intend to amendment, whether they voice their interest in amending matters, whether they voice their interest in amending matters not to the court. there's a pleading before the court. So the argument that you do not know how to respond to the discovery does not go very far with this court. See what I mean, man? This judge is on the ball and not falling for the bullshit of Scientology lawyers. There's a current pleading. That's the only pleading. Whether they intend to do it by stipulation or whether the court will grant leave, until that happens, there's a current pleading. You know what the issues are, right? Today. And that really has little to do with the stay or not. But I do appreciate your position. Lastly, RTC. Now, just to define what that is, a pleading real quick so we don't get too lost. A pleading is a written submission that sets out claims, allegations, arguments, or evidence. So lastly, RTC, or Religious Technology Center, the judge asked. Mangels, yes, Your Honor. Robert Mangels. I join with Mr. Forman. This law firm's been involved, new law firm, for 6 to 8 months. They've never mentioned an amended complaint until last week when we finally pried it out of them that they were going to file an amended complaint. We do not know who the defendants will be. We do not know what the causes of action will be, what they will be. It's essentially really unfair to ask us to proceed without a viable complaint on file. If they wait months to file an amended complaint, we'll have to start all over with discovery. The court should consider at least staying this until they file their amended complaint. I assume they can do it tomorrow. So I don't understand what the problem with them giving us the amended complaint is, frankly, Your Honor. Judge, well, I don't understand how you could possibly not know that you have a pleading. There's a pleading before me. People always say, maybe I'm going to do this or that. You can respond to discovery. With that, plaintiff wants the case to go forward. I understand. They're not asking for limitations on the stay. I understand each of your respective positions, and I appreciate it. I'm lifting the stay. I don't know how much time is left, so on the next court date, file a joint report on what you believe is the time left regarding you subtract the time told from the time this case has been active. How much time we have left, I have no idea. I leave it to the parties. I will say this is 44 pages of filings. Each page has basically 10 electronic filings. So we're talking about 400 plus filings. That's Scientology specialty. They love massive filings. They personally will have no problem with that. So I leave it to the parties to tell me where we are. Just to make sense of that, and we're almost done here in the setting of the dates that I'm about to read you so we don't get lost in the gobbledygook. The judge is basically saying the stay is lifted, here's the arrangements, and here's the upcoming dates before the actual trial in 2025. If you can't make an agreement, I'll enter an order. And this is for a case that's been stayed for a significant period of time, i.e., so let's fucking get on with it. Now, with that being said, my trial dates are a year out. I need to know up front if that's a little ambitious. If so, I'll just kick it out further, but I have trial dates a year out. Plaintiff Edwards. Edwards, yes, Your Honor. I think without getting into discovery, it's hard to know, but it might be slightly ambitious from my point of view. Judge, okay, so I'm going to kick it out 2 years. Stand by for a drink of water. So that'll give you plenty of time for any of the other issues to be worked out. September 22nd, 2025, 10 a.m. Okay, so there it is. That's the beginning of the trial. Final status conference will be September 10th, 2025. 30 minutes before that at 9:30 a.m. And post-mediation status conference will be on May 16th, 2025 at 8:30 a.m. So there's some of the dates before the actual trial and the trial itself. First off, does that work for your calendar? Edwards says, yes, Your Honor. Judge, does that work? Counsel Anderson, yes, Your Honor. Your Honor, at the risk of rocking the boat, when we've got a date, I might request 1.5 years as opposed to 2 years. But if it's 2 years, it's 2 years. Judge, right now it's 2 years. So you're going to give me, we're going to set a status date in about 90 days. I want to make sure I'm not outside the 5-year period. We're going to see each other sooner than that. Anderson, I'm certain of it. Judge, okay. Counsel for rapist Masterson, does that work for you? Brettler, yes. Judge, and the cult of Scientology? Forman, yes, Your Honor. Judge, does that work for RTC or Religious Technology Center? Joseph Mangala, yes. Judge Kalra, okay. So the parties are ordered to familiarize themselves with courtroom information as part of the case management order. You're free to file motions to compel. However, the court does conduct informal discovery conferences prior to hearing the motion so you can save yourself resources and schedule it first. Again, these are dates that are being standard that are being set up before the actual trial. And Scientology will do everything. Again, this is shenanigans number 3 we're covering. It's only been a week since the case has gotten a go-ahead and the stay was lifted. This is just a tip of the iceberg of everything they're going to try to pull between now and 2025. If I suspect there's a lot of discovery disputes, as I told the last party, you're free to set up a referee by stipulation. If not, if there's no stipulation, the court will hold whoever the moving party is to the standard under the law, which is an onerous standard. In addition, the parties are ordered to comply with local rule 3.25, meet and confer at least 5 days before the final status conference and file joint electronic documents. We will set further status. I expect, additionally, it'll be 90 days out. Therefore, we may have to do it sooner. January 10th, 2024 at 9 a.m. Does that work for Counsel Edwards? This is the first date, less than 3 months from now. That's kind of an official date, again, leading up to the trial in 2025. Edwards, yes, Your Honor. Judge, Counsel Anderson, yes, Your Honor. Counsel for rapist Masterson, yes, Your Honor. Counsel for the cult of Scientology, Forman says, yes, Your Honor. Judge Kalra, counsel for religious technology, Mangels, yes. So judge says, so plaintiff, unless you want to give notice, I'm going to ask that parties waive notice. Plaintiff Jane Doe 1, waive notice. So they all say yes and waive notice. And that's kind of the end of that. Okay. So the reason that's, like I said, I just wanted to show you Scientology is so stupid because in the last 3 shenanigans that they've done, well, they've always shoot foot bullets because what they've done here is they've made public when they didn't have to that statement that I just read out. And there's no point in actually doing that except trying to make the court and the judge wrong because the judge did not misrecord it. It's just Scientology thinks that they're above the law. And to me, it seems like they're kind of pricking the judge, trying to say you fucked that up too after accusing them of lying, which we covered in the last video. It's just crazy, man. And like I said, guys, this is just the beginning. It's just 3 shenanigans in the last week. We have 2 freaking years before this thing comes to trial, and it's just going to be funny to watch them. They're totally tone deaf to how the public, the judge, and everyone else that's not in a cult around them responds to these things. But in their world, it all makes sense, and they're far superior to any WOG justice. Sorry to use that word. But that's what they say. So going through any questions, looking for any question marks real quick, my friends, before we roll out of here. There's more to come, of course, because there's always bullshit going on. Let me just see if you have any questions before we roll out. Geez, there's a lot of you guys here. If I missed anything, if you don't mind, leave them in the comments afterwards. You know, I always check when I have time, and I'll answer any questions that you guys have, but I don't see any question marks. So, like I said, more to come. Please like, share, subscribe, and we'll see you on the other side.
I found out long ago it's a long way down the holiday road.
don't, but keep on dreaming. This is